Okay, good morning to everyone and welcome to the fifth part of the first International Information Society Law Center Conference. I am Paulina Kowalicka, a researcher at the University of Milan and a principal investigator of Information Society Law Center. First of all, I would like to thank all the speakers of this day, and in particular the speakers of this session, regulations session, that will be divided in two parts. In the first part, we will talk about the Product Liability Directive update with Francesca Gennari. Then we will discuss about the abuse of economic dependence in platform-to-business relation with the Samuel Scandola. And at the end of the first part of the session, we will deepen the need for regulation central bank digital currency with Marco Dmitrievich. Then we will have a discussion moment when the speakers will have the opportunity to answer some questions or comments that arrive from scholars. After the discussion, the second part will start with Chiara Gallese and her presentation about the Artificial Intelligence Act proposal. Then we will discuss about the liability for autonomous and incorporated artificial intelligence with Juanita Goicovici. And at the end, Jose Bello will delve into the concept of artificial intelligence in the Artificial Intelligence Act. So we can start with Francesca Gennari. Please introduce yourself and your lines of research before the presentation of your paper. So thank you, Francesca, and the floor is yours.
Thank you, Paulina, and good morning, everyone. My name is Francesca Gennari. I am a PhD candidate at the University of Bologna and Mykolas Romeris University of Vilnius. And I, first of all, would really thank our chair, Dr. Paulina Kowalicka, and all the people that are involved in the organization of this event. My main line of research concern the liability of Internet of Things objects, IoT for short, especially with reference to the domestic environment. So even though I focused mostly on private law, I also, during my years as a PhD student, I also delved into issues concerning especially data protection and competition law. But coming to the object of the discussion of today, I would like to illustrate you briefly the relationship between the Product Liability Directive update proposal and what is new in store for domestic IoT. Why I want to illustrate this relationship? Because of two main reasons. First of all, domestic IoT are fast populating our own homes. Suffice to think about voice assistants or small cleaning robots. They are they're able to attract also consistent investments. And of course, they can be assimilated to low risk system. Perhaps someone might also add AI system, and I would gladly discuss about this with our colleagues in the same panel that who will talk about Artificial Intelligence Act. So very briefly, my presentation will be divided mainly in two most important parts. The first one will illustrate very briefly the concept of the Internet of Things, but also of the main lines of the Product Liability Directive that is applicable right now, and why the update was needed. Then the core part of my presentation will describe what the provisions are that are most relevant and are able to impact the production and diffusion of domestic IoT. If there is time, I will, but I can also discuss it within in the discussion space that we will have. I will also try to highlight what are the problems and issues that the Product Liability Directive Update, PLDU for short, might have with other important legislative acts that will also be applied to the Internet of Things, such as the GDPR and also the two directives on the supply of digital content and digital services, 770/2019, and on the aspects of the sale of goods, including goods with digital elements, number 771 of 2019. So let's start. I bet that most of you know what the Internet of Things, IoT for short is, but I will just give a brief synthesis. Well, it's a technology that is almost 24 years old, and that roughly consists in basically putting sensors in objects that are able to collect inputs and stimuli, both from humans and from other connected objects. Then these inputs are processed generally in the cloud, so for our purposes outside the home, and then a reaction is given back as an input, so to say, and can be, for instance, a movement, if you can think of your cleaning robots, or also like a reply to yourself, such as your vocal assistant in the home. Why it was very successful? Because it's a very adaptable technology and can range and be applied from healthcare solutions to, of course, domestic ones. Despite the importance and also the economic relevance of this technology, the EU hasn't yet qualified the IoT legally, or at least in an explicit way. Let's say that there are several documents, such as the two directives that I mentioned before, that hint at the concept of IoT with the idea of goods with digital elements, but maybe the closest definition to the IoT is now found in the proposal for the Data Act at Article 2. Anyhow, why does all this relates to the Product Liability Directive? Because with the development and also the let's say, becoming mainstream of this technology also for domestic applications, also the Product Liability Directive needed an update as a consequence of the 2018 refit check. The refit check is a procedure that is carried out by the European Commission in order to evaluate the soundness and effectiveness of legislation. And the result was a mixed result judgment, because on the one hand, the Product Liability Directive is one of the oldest parts of the consumer law acquis communautaire, as it is more than 37 years old, and it hasn't had any major modifications. But there was the need to update more than 30 years of the Court of Justice jurisprudence on it, and also there was a feeling, especially in the field of legal scholarship, that the application to new technologies might become difficult with the text as it was. So as a consequence of this, the expert group on the liability of AI and new technologies, included the IoT, was created, and the main outcome of the study of this expert group was that technologies had to be divided into two groups: high risk and low risk technology. And this is a division that applies to the AI Act, but also to the twin proposal to the PLDU, which is the AI Civil Liability Directive. the IoT for the home can be considered as low-risk technology. And according to the expert group, strict liability should not apply to them, but we see that the story went differently, because the Product Liability Directive that is applicable now and the Product Liability Directive update are strict liability instruments, meaning that the plaintiff has just to prove the defectiveness aspect of the product, the damage, and the causal link between them. And here comes the problem. So the first order of problem concerned the status of software. If by using an extensive interpretation it was possible, and it is still possible because it's still applicable, to apply the Product Liability Directive to software within the device and consider it as a good, it was not possible to use this interpretation for the so-called standalone software, meaning the software that is not present within the device and that can be downloaded, for instance, an app. Second order of problems, the causality link. Basically, let's imagine that you have a small cleaning robot. It has always behaved normally, but at some point it starts moving erratically, it overeats, and it bangs onto the wall, and your apartment catches on fire. It is intuitive to associate the causal link to the malfunctioning of the product and the damage you endured, but it's not so simple to demonstrate it in a court of law. And even lawyers are not technological experts that can explain it very clearly, as even the smallest IoT has a very complex chain of production and supply chain. So the product liability, as it is written right now, does not reflect the new systems of production of the digital age. So that is why the proposal on the product liability update was presented last September. It is quite a lengthy proposal. It has more than 20 articles. They are all important, but I will just concentrate on the ones that I think really relate to the product liability. So the first group of products concern the so-called status of software and data. Basically, at Article 2 of the PLDU, it is stated that software can be considered a product. And this is a big revolution, because with reference to the product liability, goods and services distinction does not apply, as software can be considered a good or a product. The same thing can be said to data. It is not only an enabler of fundamental rights if it is personal data, but or a commodity according to the two directives that I mentioned before, but it can also be a product that can be damaged. In fact, Article 2, paragraph 6c states that discussing all the kinds of damage, there is damage from corruption or loss of data, even when it's not used exclusively for professional purposes. And here, given the fact that personal data are not mentioned, one can also wonder what is the relationship with the household exemption in the GDPR. Then another article that testifies the higher status maybe of software and data compared to other objects which are still covered by the new Product Liability Directive is Article 10, paragraph 2. It's an exemption to an exception to an exemption of liability. Basically, the producer or now manufacturer or economic operator can be exempted from liability if it proves a series of factors, one at least. And the number 3 under letter C is that the manufacturer cannot be faulted if the defect appeared after the product was put into service. But this exemption cannot apply if the product is a related service or software included updates or upgrades or the lack of. So it's very important. And this allows me to go to the second group of articles that is very important, which relates to cybersecurity rules, and especially in Article 6 concerning the elements, to evaluate the defectiveness of a product. There is a specific reference at Article 6, paragraph letter G, to product safety requirements. If the manufacturer does not respect product safety requirements, included cybersecurity requirements, then the product can be considered and presumed, we will see, defective. This leads me to the final group of procedural rules, I call them, that are able to prove either the defectiveness or the causality link. It's article number 8 and number 9, and they are similar to article 3 and 4 of the twin proposal concerning the AI liability directive, and they are, despite they are different in the framing, their function is the same, which is basically to harmonize indirectly the procedural rules of member states, which is a bit unusual, let's say like that. So the first article, Article 8, concerns the so-called disclosure of evidence. In paragraph 1, it basically states that member states must empower national courts to have means to ask the defendant to disclose relevant evidence concerning the functioning of the product whenever the plaintiff has given evidence that show the plausibility of the connection between the defect and the damage that it has endured. But the Product Liability Directive update, as the actual Product Liability Directive, is not a proper consumer protection let's say instrument, but it is an harmonization one. Hence, also the issues of manufacturers must be taken into account, and this is explained at Article 8, paragraph 3 and 4, in which basically the courts must also, during the process of disclosure of evidence, ensure that intellectual property rights that are disclosed in this process are protected and by confidentiality after the proceeding is concluded. And then Article 9, it's titled Burden of Proof. At the first paragraph, it explains the main functioning of the Product Liability Directive that I already explained to you. The plaintiff has to prove the damage, the defectiveness, and the causal link between the two. But given the fact that it's difficult to prove, especially in technological context, especially the defectiveness and the causality link, then the paragraph 2 of the same article states that there are some presumptions that can be applied to presume the defectiveness of the product, which basically are either the manufacturer has refused to the order concerning the disclosure of evidence, so you can presume the product is defective, or the claimant establishes that the product does not comply with mandatory safety requirements laid down in union law or member states law, and finally, the claimant establishes that the damage was caused by an obvious malfunction during the normal use. So Article then 9, paragraph 3 states that the causal link can be presumed whenever the damage allegedly caused by the object is typically consistent with the defect in question. It's a rather vague wording, and of course the judge will have to take into account, I guess, the opinion of experts, impartial experts on technological things, and also the cybersecurity national authorities, included the European one, ENISA, in order to have a clearer view on this. Finally, Article 9, paragraph 4, establishes that the court can when the plaintiff faces excessive difficulties because of the state of the technical art or scientific complexity of the products, it says that it can presume the defectiveness of the product or the causal link whenever the claimant has demonstrated that, on the basis, of course, of sufficient relevant evidence, that the product contributed to the damage and that it's likely that the product was defective, or that its defectiveness is a likely cause of damage, or both. So we see, and the final paragraph states that all these presumptions are rebuttable. So the manufacturer can actually defend itself if it deems that it's necessary, which I think will always do like that. But we see that all these presumptions help, or are thought to help more the consumer than the manufacturer. I will quickly highlight, I don't want to overdo my time, but I wanted just to point out that the connection with other important legislative acts such as the GDPR is not really clear. Formally, the Product Liability Directive does not overlap with the GDPR, but it can happen that personal data can be damaged during this kind of judgments. So it depends on the member state whether a product liability judgment concerning data and also like a data protection one can be done together. That's a so-called cumulus rule. And the same thing happens with the directives 770 and 771 2019, because most of the times products liability damages happen when there has been a contractual relations, like I buy this kind of IoT objects, hence there is also a contract at the beginning. So in this case, there are two different kinds of liability, contractual liability and strict liability. And in many countries, it's not possible to cumulate both in the same proceeding. So we will have to see what will happen. So thank you for your time, and I'm looking forward to answer to your questions.
Thank you so much for your presentation, Francesca, and congratulations for your work. It was very full of insights. Now we leave the floor to Samuel Scandola. Please introduce yourself and your lines of research before the presentation of your paper. Thank you,
Thank
Samuel.
you very much. So my name is Samuel Scandola, and I'm a PhD candidate at the University of Trento. And my research focuses on the digital economy, more specifically platform to business relations. And this is a part of my research, the one that I'm going to present today, which is the reform proposal. So as anticipated before, my presentation regards platform to business relations, which are a subset of business to business relations, which, however, have peculiar features, and more specifically, digital platforms are usually the stronger party in platform to business relations. So there is basically a power imbalance between digital platforms and business users. And due to this, the analysis of platform to business relations should be relevant and should be investigated. First of all, of course, the concept of digital platform should be defined. And digital platform can be defined as an information technology service that is offered through the internet and that facilitate the interaction between two or more unilaterally or reciprocally interdependent groups of users. So a digital platforms is basically an intermediary between two or more groups of users. However, digital platforms, although there might be a very general definition, are not the same. There might be three categories of digital platforms. The first one is transaction platforms, which are online platforms that facilitate a transaction between two or more groups of users, where transaction means any exchange of resources or any economically relevant interaction. And for example, marketplaces like Amazon or app stores can be example of transaction platforms. Non-transaction platforms, by contrast, are online platforms that facilitate any unilateral interaction between two or more groups of users. And of course, this interaction cannot be a transaction. Otherwise, they would fall into the aforementioned category. And examples of non-transaction platforms are advertising-funded social networks like Facebook, Instagram, Twitter, and so on, and search engines like Google. And finally, there's a third category, which is somewhere in between transaction and non-transaction platforms, which is that of, I call it non-transaction matching platforms, which are online platforms that allow for bilateral interaction between different groups of users. So there is bilateral interactions, but this interaction is not a transaction. And these platforms usually use an advertising-based business model. So an example of these platforms are dating apps like Tinder, for example. I will only focus, however, on transaction platforms. So the analysis of platform-to-business relations in this presentation will regard only transaction platforms due to the differences of these three categories. So transaction platforms are characterized by several sources of market and or bargaining power, especially network effects and economies of scale. There are also other sources of market power like economies of scope, the role of data, which exacerbate network effects, economies of scale, economies of scope, and so on. And finally, high switching costs. With regard to bilateral indirect network effects, they basically arise when users of one side of the platform attract more users of the other side of the platform and vice versa. So more users on one side will attract more users on the other side, and more users on this side will attract more users on the other side. So basically, once the online platform manages to get one of the users, one of the sides on board, network effects will trigger a virtual circle for the platform that manages, so basically, which triggers, so this virtual circle that might increase and market power, the platform's market power and bargaining power, increasing the concentration of the market, as all users will converge in the platform, basically. And of course, network effects can act as a very important barrier to entry for new entrants, as new entrants will have to convince at least one of the sides to join the platform in order to attract the other. This is a so-called chicken and egg problem in economics. Economies of scale, the other main source of market power, occurs because digital platforms, online platform markets are characterized by high fixed costs and very low variable costs. Digital platforms require large investments in their initial stages in order to develop the software, collect the necessary amount of data, and convince, of course, as I said before, at least one side to join the platform. As a result of these features and economies of scope, data, and so on, digital platforms, transaction platforms, usually possess a high degree of market power, which leads to concentrated markets. And of course, because of that, transaction platforms are structurally the stronger party in contractual relations between the platform and the business user. As a result, the platform may abuse its market and bargaining power by engaging in exploitative and/or exclusionary conduct. Every transaction platform could engage in exploitative abusive conduct, which usually translates in the imposition of unfair clauses, for example. However, only transaction platforms that are or would like to be vertically integrated are likely to engage in exclusionary conduct. For example, by refusing the access to business users, by promoting its own products in the downstream market, the so-called self-preferencing, or by deactivating the business user's account. A platform vertically integrates when, besides offering an intermediary service, the platform also offers directly goods or services in the intermediate market. So basically, Amazon does not only allow business users to interact with buyers, but also sells its own products. This is a vertically integrated transaction platform. The EU legal framework, which is the legal system that I'm analyzing, does not provide sufficient protection to business users in platform-to-business relations. There are three main provisions that might be relevant in my analysis. The first one is Article 102 TFEU, which is, of course, the prohibition of abuse of dominant position. However, Article 102, well, its goals lie in the protection of undistorted competition, provided that it enhances consumer welfare. So the focus is on efficiency and not in fairness, which is the assumption of this presentation. And because of that, in exclusionary abuses, Article 102 can only protect as efficient business users, provided that the conduct is capable of affecting competition or impacting consumer welfare. Besides, Article 102, for example, requires market definition in order to assess dominance, and market definition in transaction platforms is particularly complex, as transaction platforms are multi-sided markets. As I said before, they allow interaction between two or more groups of users. So they have more than one side, of course. And because of that market definition, well, the traditional instruments to define a market, the relevant market, cannot be fully applied to digital platforms because of the nature of digital platforms and because of the non-neutral price structure. Usually in digital platforms offer to one of the sides a free service. So for example, I don't have to pay to use Amazon, while a business user has to pay to use Amazon. So this is a non-neutral price structure. And because of this, well, because of the multi-sided market nature of digital platforms, it is not clear whether one or two markets should be defined. And when it comes to the price structure, it is not clear whether quantitative methods of market definition might be used. And a result of that, usually only qualitative methods should be used to define a market in digital platforms, whose outcomes are largely arbitrary and can often lead to under or over enforcement. Second piece of legislation is Regulation 1150/2019, which directly addresses power imbalances in platform-to-business relations, and it is meant to provide a certain level of protection to business user. However, although its scope of application does expressly include transaction platforms. It fails to properly tackle abusive conduct that the platform may engage in, as it lays down mostly procedural and disclosure obligations on the transaction platform. So provided that the platform complies with those obligations, it is then free to engage in any kind of abusive conduct. And finally, the very recent Digital Markets Act imposes several obligations on digital platforms. However, although these obligations include most forms of abusive conduct defined above, so the exclusionary and the exploitative conduct, it only applies to gatekeepers. And a transaction platform will be considered a gatekeeper under the Digital Markets Act if it's designated as such by the Commission. So you need a designation of the Commission in order to have the Digital Markets Act applied to a digital platform. And as a consequence of that, Digital Markets Act does not apply to the very majority of digital platforms that do not reach the high thresholds set in the Digital Markets Act, which are really high and which are likely to include only the largest platforms. So provided there is a power imbalance in platform to business relations, and the EU legal system does not provide adequate protection to business users, the proposal of this presentation is a EU prohibition of abuse of economic dependence, which might fill this gap in protection while still allowing for a certain degree of flexibility. Why am I saying this? Because on the one hand, business users are usually economically dependent on digital platforms, as I outlined above, so meaning that they do not have reasonable alternatives to platforms, which could either be because digital platforms hold a dominant position on the market, or because of high switching costs, which can happen, as I said before, due to a bilateral network effect, so collective switching costs, and the difficulty of convincing at least one side to switch en masse to the new platform, and a practical lack of data portability. I will be glad to talk about this more in depth later, in case if somebody asks. And on the other hand, abuse of economic dependence allows for a certain degree of flexibility, because although in general it can be stated that digital platforms are the stronger party in platform to business relations, it is not always the case. So sometimes it can happen that this power imbalance does not occur in platform to business relations. So when, for example, non-platform sales channels might not be a reasonable alternative to some business users, for other business users, especially very large firms with a strong brand reputation, could fully rely on non-platform sales channels, also their own. And of course, in this case, these business users are unlikely to be economically dependent on the platform, as there is no lack of reasonable alternatives. And besides this, a EU prohibition of abuse of economic dependence might be useful, as it is still it is already part of the legal traditions of most member states. So this wouldn't be a proposal which does not belong to their legal traditions. And finally, efficiency does not necessarily have to be the goal of the abuse of economic dependence, as it is instead in competition law at the moment, of course. And this happens also in some states, for example, in Italy, although the it is debated. And for this reason, a EU regulation of abuse of economic dependence could pursue the goal of fairness and should, in this case, as it is the assumption of the value assumption of this presentation. An abuse of economic dependence might have also a adequate legal basis, which could be identified in Article 26 and Article 114 TFEU. And such a legislative intervention could fall into the digital single market strategy regarding the development of trans-European networks, where the European Union has a shared competence with member states, however. And finally, some features that these abuse of economic dependence in platform-to-business relations should have. First of all, it should harmonize the laws of EU member states while leaving untouched abuse of economic dependence regulation in other industrial sectors in order to avoid over-regulation. With regard to the features, the requirement of economic dependence shouldn't require prior market definition, as I highlighted before. It should be a problem in antitrust law, and it is a problem in general to define the relevant market in digital platform markets. And due to transaction platform structural markets and bargaining power, a EU regulation should include a presumption, rebuttable presumption of economic dependence, such as in Italy. And second, with regard to the abuses, these EU regulations should provide a non-exhaustive list of abuses, which should, however, include platform-specific conduct in a way similar to the German and Italian laws on abuse of economic dependence. And finally, with regard to enforcement, it should be both public and private, as public enforcement could enable national competition authorities or any other competent authority to stop abuses that affect large numbers of business users, while private enforcement could ensure adequate protection for practices that affect one or few business users. And finally, courts should have the power to impose both cease and desist orders and other behavioral remedies, such as obligation to enter into agreements with the business users, besides compensation. Thank you very much for your attention. I'm sorry if my presentation was probably a bit longer than 15 minutes. Thank you very much.
Don't worry, Samuel, and thank you so much for your presentation, and congratulations also for your work. It was really interesting. Now we leave the floor to Marco Dimitrievich. Please, Marco, introduce yourself and your lines of research before the presentation of your paper. And so thank you, Marco. The floor is yours.
Thank you very much, Paulina. It's my great pleasure to participate at this conference and to share some fruitful thought, I believe, about the different aspects of digital revolution and digital society in different legal branches today. My name is Marco Dimitrievich, and I am an associate professor at the Chair for Law and Economics at Faculty of Law, University of Niš, and currently Jean Monnet Model for European Monetary Law academic coordinator. As you can see, the subject of analysis in my paper is actually the potential need for regulation of central bank digital currency, where we actually analyze some major point about monetary legal basis and some challenges in contemporary monetary law. When we speak about the influence of technological revolution on the concept, structure, and implementation of monetary sovereignty, it is important to emphasize that in some sense we actually speak about the collision between the orthodox and the contemporary monetary law discourse. At first glance, it seems that monetary sovereignty as the eldest and almost primordial component of political sovereignty shall be unchanged and consistent over time, but that was not the case in terms of technological revolution. The position of the central bank as the keeper of the monetary sovereignty was not passive and trapped in the realm of some classical scientific thought what central bank is and what central bank should do today as the market. In contrary, we can see one practice that actually invoked, that listened, that respect the new way and pattern in which monetary habitants want to fulfill their monetary preferences in terms where market is in process of perpetual dynamism and become more and more unphysical, become more cyber and abstract, and so far away from some general thesis of common economic policy, what is the main function of the market. When we speak about monetary habitants, we actually speak about the citizens who live under concrete monetary jurisdiction, where the state as the keeper or the central bank as the keeper of monetary sovereignty actually implements all that prerogative which are in the structure of the monetary sovereignty. As you probably know, monetary sovereignty is the eldest and the most important part of political sovereignty. It is not the synonym to the fiscal and financial sovereignty. And the origin of the monetary sovereignty was actually in Roman private law. Even some monetary law theorists believe that it was generated even earlier in ancient China and Babylonian Empire. And here we actually speak about that power of the state to define money and to define the main function of the money today. Central bank, of course, is not just a static holder of that power, or lex monetae cudenate, as we call it in science of monetary law. It is also a supreme lawmaker, which is quite flexible in terms of dealing with the consequences of some financial and economic crisis, where there is real and logical need to act promptly and to act efficiently from one side, but that also includes acting which must be credible and ingenious from the other side. And in terms of that crisis, global financial crisis, and sadly also in terms of pandemic crisis, there is some good example of that flexible and very rapid act of a central bank all over the world, where we can see also that implementation of tendency to provide that monetary conduct in a more human approach in order to become more altruistic today, which is one of the major tendency in international monetary law and that legal regulation of monetary affairs. In that circumstances, the central bank also provides sui generis monetary legal solution for fulfilling that legal gaps that exist in primary monetary legislation. And as you probably are familiar, many of them was the subject of the monetary disputes in front of not just European Court of Justice, but also some national court and financial court. We have a lot of examples which refer to the Pringle case, European Stability Mechanism case, outright monetary transaction, ladder case, and etc. The nomotechnique of central bank, especially European Central Bank, is sometimes very impressive, and from that legal point of view, technical legal point of view, actually very artistic. And it is the major force of disintegration process, that qualitative and substantial disintegration process. So today we have the central bank law as independent and positive legal branch in contemporary legal order. When we speak about that law of the central bank, we actually think about the totality of legal norm which define institutional position, regulatory competence, and public monetary conduct in function of providing monetary stability both at national and supranational level. Why is that important? It is important because monetary stability is pure public good, as same as internal and external safety, efficient judiciary, efficient public administration, and etc. And in that process, central bank is actually actor primus because we can see that there is a lot of example in practice where law of European Central Bank especially confirm its relevance and maturity as legitimate branch with some very specific measures, very subtle and also very luxurious axiology in supporting and confirmation that dualism of the central bank competence today. Its major task, of course, is price stability and some support to that long-term economic policy, and that is undoubtedly true. But there is also tendency of acquiring some new powers in activities which refer to performing financial supervision and some contributional activities controlling financial crimes, cohesion policy, environmental policy, and some other segment of public policy. In the field of monetary law, when we speak about the digital currency, we must be aware that there is no place and no space for some unplanned and superficial and partial modus operandi, because the frequency, that massive popularity, and of course benefits of using not only digital but also electronic currency, because digital and electronic currency are not the synonym, at least not in the law of legal regulation of monetary disputes, because all of this demands very a reliable, firm, solid, and sustainable jetty against the consequences of micro and macroeconomic crisis today, with potential to radically change the adopted habits of consumers in digital environment. In monetary law literature, we can also see one tendency that monetary conservatism, which nowadays is gone with the wind, will probably ignore the fact that citizens want to implement their preferences in digital market at a more modern and sophisticated way. Monetary law conservatism will probably treat that as a temporary or short-lived sign of some monetary redundancy or etiosity. But we had a lot of example in monetary law history that always monetary habitants are actually always in search for some new, more consistent way of manifestation of desired preferences. And I would say they have natural right, of course, to provide by state some solid and healthy currency. That is some special category of economic right which can be derived from the monetary sovereignty. When we speak about digital currency in the broadest sense of the word, in science of monetary law, we actually think about the set of operation based on application of some mathematical algorithm technology that enable the conversation of the process from the real world to the analog world or basis, while adding some new properties to existing conventional means and function of payment. Of course, it is important in this manner to make some distinction between electronic and digital currency. As I previously emphasized, electronic currency is accepted as a legal meaning of payment. It is regulated by monetary legislation, central bank legislation, in the form of the prepaid chip integrated in the plastic card or similar software, and as such, it enjoys the full protection of the state in the court, of course, in the case of the fraud or some other illegal activities. At this point, it is also important to emphasize that that idea of cashless society with digital and electronic currency is not that new in the science of monetary law. For example, even in 15th century, Nicola Copernicus, as you know, is the famous astronomer, in his work, De Moneta Coordinate Razione, actually perceived the society where we use something very different from that classical banknote or monnaie scripturale, as we call that classical cash or classical money, which is not in digital form. And also we have some other works such as Edward Bellamy looking forward from 1888, where he also predicted a society where there is no need for further existence of the central bank. Of course, digital currency, electronic currency in the monetary law represent an example of monetary and financial innovation. We have a lot of innovation during the history, and some of them was not that successful. But the main precondition for digital currency of the central bank would be the form of the lump sum liability of central bank, which is available to all economic agent without some specified conditions. One possible way for eliminating all that risk, which refer to the use of the central bank digital currency, is maybe in making approach to general public in a way which is not that direct by using full reserve bank as normative option. The main ratio in this proposal is actually in a novellation of the central bank legislation in order to provide some new subjects to keep their reserve in order to escape on flowing already established monetary function. In that sense, that would break probably for some limited period of time the link between digital currency issuers and digital currency users in order to make all that preparation in central bank legislation. Of course, introducing new goals to central bank should not be at the burden of the existing powers, which recall for the parification by using and choosing concrete goals as the dominant one in specific moment of the monetary history. But if we imagine a situation where we have significant increasing in digital currency share in total money demand and supply, but from the other side we do not have a precise legal answer how to regulate that in monetary conduct, that would be quite dangerous for preserving that monetary stability as public good, and it would be quite tricky to protect the right of the monetary inhabitants or the citizens in that manners. We have actually some very important example in this area, and one of them is actually that joint statement of the 8 most important monetary institutions in the world, which include Bank for International Settlement, Bank of Canada, European Central Bank, Bank of Japan, Central Bank of Sweden, Switzerland National Bank, the Bank of England, and Fed, of course. This is an example of soft monetary legislation, as you can see. It is par excellence example, of course. And in this act, we can actually see that tendency that digital currency is not goal per se. It is in the function of general support of monetary policy targets, such as price stability and inflation control. But it is important because it gives us opportunity to plan that future normative approach of central bank digital currency involvement. Of course, it is also important to emphasize that in this act, we can maybe see the elements of that future path and best normatively and economically efficient way to introducing central bank digital currency and maybe to avoid some effect of congestion, especially in the field of central bank powers and jurisdiction, which is not only limited to monetary policy, as we said, also that includes fiscal and financial policy and some other segment of public policy. Since this document, it seems that central bank a little bit ignored this form of monetary innovation because they believe that the increasing of digital currency, Bitcoin and some other form of digital currency is not that serious and not that significant. But today we must understand that digital currency is not a substitute for traditional money. Also, there is no competition between them, and that is something which is for the very first time very clearly and very profoundly written in this act, but also in one other which is very important in the field of European monetary legislation, that is report on digital euro, also example of soft monetary legislation. In this report, there is a clear hypothesis that the process of digital currency issuers must follow the synergy of industrial sector as one of its main promoter, and that is something which is actually quite understandable. And this report does not insist on promptly and mandatory regulation of digital currency at this point of time, but it reflects on its influence on commercial banking sector, on financial stability balance sheet, elimination risk, and some characteristic of the so-called second generation of the digital currency, which refer to the stable coins, for example, Libra of Facebook and some others. We are aware that legal basis demands the abrogation of primary monetary legislation, and that process can last for a long period of time. Analysis of the euro system in this act actually shows that digital currency of the central bank had that potential to support monetary action involving in dealing with European economic digitalization, some new channel of monetary transmission, protection of international role of domestic currency. In this aspect, we of course speak about the euro, and also provide some very substantial and very good environmental approach in banking and corporate finances, because beside that tendency of making that human approach in public monetary context, there is also a tendency of greening international monetary finances, which is actually quite important today. European Central Bank in this report actually makes some distinction between the so-called offline and online euro or digital currency, where both types are actually mutually consistent and compatible. Differences is more technical in its nature and refer to some different model of client identification and different model of supervision. In last line, Central Bank is of course the supervisor, but the percent of that control and supervision, which is more or less direct or indirect one, is present. For example, when we speak about that offline digital currency of the central bank, it actually refers to provide using without third-party intervention and demands availability through some very sophisticated technical device. While from the other side, online digital currency of the central bank demands certain fees, paying certain fees for its using, where of course the rate of that fees would probably decline over time, and that funds can represent some additional fund for monetary measures portfolio, which is not of course without its importance, especially in terms of consequences of financial and debt crisis in many, not only European countries, but all over the world. The position of the central bank also referred to smart using of technology in public monetary management towards technocracy in monetary banking and corporate financial law, and escape the partial solution, which is very, very important, with that limited interoperability and insufficient promotion of financial inclusion. We have some successful example at the level of national monetary legislation. For example, there is one experiment of France Bank, Société Générale Bank, which is actually include in accounting of tokenized bond with some actually quite impressive success. There is also some open question, but we must be aware that this experiment with tokenized bond was made in a condition which referred to the experimental scenario, monetary scenario. That means that that ambient was free of current political and legal determinant, and reliability of current technology actually confirmed that this is all in very early phases of its development. That is the phases we can actually call monetary nasciturus, because it is so early to provide and to maybe give some sustainable conclusion about that process in the future. But from the other side, there is one very interesting thought that some monetary law theoreticians believe that this situation nowadays with digital currency at international monetary order and traffic is very similar to the one that occurred in 13th century. In 13th century, just a moment before the appearance of the banknote, as we use today. But that is just a possibility, of course. Also, there is some opinion that digital currency of the central bank is not the new kind of money, that it is just the new form of money. But if we speak about the bond, or maybe that balance sheet of the central bank in digitalized form, we must be aware that in current central bank legislation, there is no some efficient normative regulation of that aspect. So it is probably more the new kind than the new form of the money. From the other side, some profound monetary legal analysis actually confirmed that validation mechanism of digital currency transaction is quite tricky and challenging for monetary lawmaker, because that mechanism of its issuance is not purely legal in its nature. It also demands some science and some knowledge from economy, from natural, from other sciences, of course, technical sciences. And because of that, we must be aware that this is still just a process at the beginning of its development, at least in the science of the monetary law. But if citizens want to use digital currency of the supreme monetary institution, which central bank is, of course, we must not ignore that because of tendency of redefining monetary order in that more human approach. And we must not forget that if we have that situation that the issuer of the digital currency is private company, that there can be collision between that need to protect monetary stability from one side and, of course, the need to raise some profit, because the main motive of international company is, of course, raising the profit. That is not the monetary stability. Maybe, hypothetically speaking, based on some solution which exists in the tax law, when citizens with the permission of the state's authority, tax administration, of course, can collect certain information about tax collection process, that includes to registration almost, maybe can have some borrowed monetary prerogatives and powers from the central bank in order to, of course, make that process reliable and more easy in the future. But we must bear in our mind that in the field of the tax law, we actually only speak about tendency of sharing some task in the process of raising tax and their control. But in the field of the monetary conduct, that is actually very significant ideological and axiological issue, because we have that question: when, why, and under what condition a physical person can issue money or maybe make some task in that process. Of course, at the end, I would just conclude that today in monetary law, we must respect that hypothesis and postulate of state theory of money, that is state nominalism, which found its place in constitution in all over the world, because state is the one which defined that legal definition of money, provided its protection, it had the legal monopoly to define it. But from the other side, we also have that characteristics and demands from the so-called social theory of money. Social theory of money learn us that is also very important that the people want to use that money. And we had some example in monetary history where people did not want to use that official money of the states, or which referring to that postulate of the state theory of money, they want to use some other kind of money. We obviously, in this term of financial crisis and all these other crises, can see some benefits and also some cost of using digital currency. But that is actually one very important question which had to be regulated efficiently and effectively in the future. And that is only possible but with some coherence, cooperation between, of course, state monetary and financial institution, but we also must respect some demands which we can see in the behavior of the consumers today. Thank you very much for your attention.
For your presentation, and congratulations also for your work. It was very clear and interesting. So now we can start with the discussion. We have some questions for you, and the first question is to Francesca. I will show you. We have not much time, so maybe you can choose one or two of this question and answer.
Yes, so thank to anyone who submitted the questions. They are all very interesting. Let's say that it's difficult to pick one because they're very interesting, but well, I think that the second question I answered basically by explaining it in my exposition, and maybe it is interesting to say what is the role of the manufacturing companies in the responsibilities, because it's actually quite complex to answer it, because in the present product liability directive, there is only one subject, the producer, according to Article 4 and 3. But then Article 3 creates a cascade system if, for instance, the producer is not known, the supplier has to be contacted. But there was consistent jurisprudence from the Court of Justice, which was quite restrictive at the beginning, and people were asking directly the supplier to receive compensation for the use of a defective product, but the Court of Justice denied that. Now things are a bit changed, because there was a judgment last July from the Court of Justice, which we don't know if it, in a case which we don't know if it involved the smart objects, an IoT object or not. It was like a coffee machine that exploded and ruined a whole apartment. And in this case, though, there were several trademarks on top of it, and the consumer had decided to sue one of the owners of the trademark. And this trademark owner had replied that it was not the producer, it only owned the trademark, and the manufacturer was a Romanian company. But the Court of Justice instead said that the consumer does not have to bear the costs of the division of liability. The new Article 7 of the Product Liability Directive update goes a bit against this judgment, because it is true that now it's not called producer, but it's manufacturer. It's still the main person who is to be held liable. But there is a long series of other subjects, included the authorized representative, the importer, the distributor, and in the end, even online platforms that can be held liable, but only in specific cases, meaning when the previous subject in this cascade system line is outside of the EU or cannot be found. So we will see how it will be implemented. For sure, there was an effort from the drafters to reflect better the dynamics of the digital society, and especially the production and supply chains that are now mostly diffused. So I hope this replied the question.
Thank you, Francesca. Now we have a question to Samuel.
Yeah, can you hear me?
Yeah,
Okay.
can hear you.
Yeah, well, thank you very much for having asked this question, first of all, to whoever asked it. So I think the first thing that should be asked in order to answer this question is the definition of optimal, as of course the right or optimal measure of regulation should be defined according to the goals it is meant to pursue. So of course, if we're looking for an enhancement of efficiency, we might have a right measure, and if we're looking for an enhancement of corrective justice, fairness, and so on, we might have different right or optimal measures. So I think this is like the first things that should be kept in mind in order to answer this question. In my presentation, I assumed that fairness should be the goal of an abuse of economic dependence, in order to protect also less efficient business users from exclusionary or exploitative conduct by the digital platform. And so as this is as a general rule, and of course then in order to find the right or optimal measures, after somebody has defined what is the goal that should be pursued by the measure, there should be like over-regulation and under-regulation should be avoided. This means in order to avoid over-regulation, you should define a quite narrow field of application, but not too narrow in order to avoid under-regulation. In the case of digital platforms, as seen, they are very different, and so it should be clearly you can't regulate all digital platforms the same because, as I said, there are 3 different kinds of digital platforms, and also within these categories there might be different digital platforms. So, for example, within the category of transaction platforms, there might be app stores, marketplaces, and so on, and these differences should be kept in mind. And this is also the approach that has been adopted by the European Union in the Digital Markets Act and in Regulation 1150/19. Of course, one should argue that there might be also self-regulation, and that self-regulation should be incentivized. But I think that in the case of digital platforms do not really have this incentive to self-regulate unless there is some form of pressure by the legislator, in this case by the European Union. And still, these attempts of self-regulation have not really worked in the case of digital platforms. For example, digital platforms, in this case non-transaction platforms, have tried to self-regulate, for example, social networks, and yet the European Commission has deemed that these attempts were not enough, and that's why it enacted the Digital Services Act very recently. And finally, to answer the second part of the question, so a possible good practice. Well, this is related to all the consideration that I've just made. In the case of my presentation, it's probably the goal is to avoid that the digital platform excludes or exploits the position of a business user. For example, when it comes to exclusionary abuses, abusive conduct, the business user should be able to operate in the digital platform, and if it is less efficient, then it will be the competition within the platform that will drive out of the market the business users, and not the digital platform that should decide whether this business user should remain in the platform or not. I hope these answer the question. It was quite a general question. I hope I managed to kind of answer it. Thank you very much.
Thank you a lot, Samuel. Now we have the final question to Marco.
Thank you very much for this question. Considering the fact that there is a huge degree of that synthetic and dialectical connection between the physical currency, classical money, and money laundering and general financial crime, I guess that the relationship between the digital currency and preventing and stopping financial crime is much more severe, complex in the case of digital currency. Of course, we must have in our mind that the task of the monetary institution, first of all, central bank and public data agency, in that process of preventing financial crime is not the primary one. It is the secondary, and that is not their main tasks. But this does not mean that that task should be diminished. I guess that every activities in this field can be very important, and in synergy with all other activities can gain to that goal, which refer to control, eliminating the risk at financial crime and money laundering, of course. But hypothetically, if we have that functional definition of the digital currency in the central bank legislation, then we'll have that situation that central bank has mandate, of course, to rigorously involve in this process. For example, when we speak about that physical currency, in example of European Monetary Union, we have that Article 28 and 29 of a single supervisory mechanism that actually empowers European Central Bank to involve in this process. Also, in this matter, it is very important to make some credible dialogue with other institutions which involve in this, that include the court, especially I would say financial court and auditor institution, because in that process they can actually successfully control this negative phenomena of the society, and maybe control that percent of illegal activities in this field. But the precondition for all this, and I would say some further analysis, especially in the field of the monetary law, is to have that definition of digital currency in central bank legislation. I must emphasize that in Serbia, we actually have law on digital property, which in one aspect give some information about the digital currency. But this does not mean that we actually have some efficient regulation about it, but I would say that maybe it is some nasciturus of that future regulation of this important question. Thank you very much.
Thank you a lot, Marco. And many thanks to the first three speakers of this session. It was a pleasure to share these topics with you. And now let's start with the second part of the session. So Chiara Gallese, please introduce yourself and your line of research before the presentation of your paper. Thank you. Chiara, the floor is yours.
Thank you, Paulina. Thank you to all colleagues that had very interesting talks this morning. I'm Chiara Gallese. I had my PhD from University of Venice. Now I am a postdoctoral researcher at the University of Trieste and will soon start my Marie Curie Fellowship at University of Turin. My line of research is about AI and law, AI ethics, in particular data ethics and privacy law. Today I will talk about the new proposal for an AI Act and the possibility of recognizing a right to technical interpretability at a European level. So I will first introduce the concept of technical interpretability and explainability, how these concepts are found in the current European legislation, especially regarding the transparency principle and the right of explanation. I will analyze Articles 13 and 14 of the AI Act proposal, and then I will present my idea about the right to technical interpretability as a fundamental right. So I don't know if our audience is expert on AI and if they are familiar with the concept of interpretability and explainability. At a legal level, you always find a lot of discussion on these topics, especially regarding GDPR. But I will talk about a slightly different concept today. It's not the right to an explanation found in GDPR. It's something different. So in the technical literature, you will find a lot of papers talking about the explainability framework and interpretable models. But sometimes these concepts are used interchangeably, so they are confused. And I will refer to the definition provided by Rudin, Cynthia Rudin. She's a professor at Duke University. In her papers, she make a clear distinction between the two terms. So explainability is defined as a postdoc model built to explain a black box model. So it's something that is not natively explainable. That there is the need of a second ad hoc model that is built specifically to understand why a black box model had given a certain output. Because in black box models, you are unable to understand the reasoning behind the output. While in interpretable models, which are also called white boxes, you can clearly, from a technical point of view, understand why the model has reached a certain output. So you can really understand from a technical point of view what elements in the data were weighted more, and what was the route that the model took to reach a certain conclusion. For example, if you consider a model, a classification algorithm in the healthcare sector that categorize upcoming patients of a particular illness into healthy or unhealthy, based on a data set that has a lot of different values, different characteristics of past patients. In this case, you put the new data from a new patient in the system, and the system would tell you if the patient is ill or if it's not ill. So if you want to understand if the patient has a certain condition, then you need to include a lot of data of this patient. For example, blood levels, vitamins or iron levels, protein levels in the blood, symptoms of the patient, the anamnesis or other type of information, age, ethnicity, weight, height, all the information that normally doctors would deem important for the diagnosis. But because of the number of these intricate features and the parameters of the model and the layers that are employed by the model to produce a certain output, the system or the builder of this model is unable to tell you why the patient is ill. So you know if it's ill or if it's healthy, but you don't know why. For example, if you ask a doctor, the doctor would tell you because statistically at this age with these symptoms, normally we find that patients are ill of this specific condition and not of another condition. We are talking about probability. But the black box model, is not able to give you this reasoning. It will only tell you if it's ill or not ill. This is, of course, I'm oversimplifying just to make the concept clear. While if you think about interpretable models, you can consider a system that predicts the likelihood of not being able to pay back a mortgage. So there is a financial institution or a bank that would allow or deny credit to specific people, to specific citizens. And an interpretable model would be the one that made clear, that can really explain the what factors that are relevant for the financial situation of the person. For example, wage or job type, age, current loans or marital status, education, and such. Such factors that were used by the model to produce an answer. So the model would be able to really explicitate the relationship found between the different data. For example, the model could suggest that from a statistical point of view, educated persons are more likely to have high incomes because their probability of getting a well-paid job is higher, and therefore these persons are more likely to be able to pay back the mortgage. Um, so you could, in this case, because the system is interpretable and you can really see the justification of the reasoning, you can also understand if there are biases in the reasoning. For example, the system could say that a certain ethnicity is statistically not able to pay back the mortgage because of a social condition. So this is the difference between a black box model and a white box model. In the case of a black box model, it would be necessary to have an additional model that would provide explainability to try to understand why the system reached a certain conclusion. From a technical point of view, it's not a matter of law or ethics, it's just a technical factor that it's not possible to understand because the black box is too complicated, or it's built in a way that it's not able to tell you why this is why the output was produced. So in our legislation, especially in the European Union, we have a very important principle, which is the transparency principle, and we also have what is called the right to explanation. So transparency is found in a lot of different regulations, especially within the digital strategy. And it's also a very important principle in the national healthcare law for informing patients and requiring informed consent. But it's also found in GDPR. So the data controller have the obligation to inform data subject about how their data is processed. And there are also other obligations regarding transparency in automated decision making. So in order to be able to challenge the automated decision, data subject needed to be informed on the criteria that were relied on the decision from the automated system. So transparency is really important, and a right of explanation has been theorized, although it's also challenged by some scholars. But we can say that it's well established in the current legal framework. There is also Convention 108 plus at Article 10, as explained in the explanatory memorandum. Data subjects should be entitled to know the reasoning underlying the processing of the data, including the consequence of such reasoning, which led to any resulting conclusion, in particular in cases involving the use of algorithms for automated decision making, including profiling. For instance, in the case of a credit scoring, they should be entitled to know the logic underpinning the processing of their data and resulting in a yes or no decision, and not simply information on the decision itself. Without an understanding of these elements, there could be no effective exercise of other essential safeguards, such as the right to object and the right to complain to a competent authority. So we see that the right to explanation is really established, it's really recognized at the international level. But what does the AI Act says regarding explainability and interpretability? So if we analyze Article 13 and Article 14, you can see that the transparency principle is an overarching obligation throughout the whole AI Act proposal. And users should be informed from a multiple point of views. For example, by having a technical documentation that they can consult. But Article 13 says that high-risk AI systems shall be designed and developed in such a way to ensure that their operation is sufficiently transparent to enable users to interpret the system's output and use it appropriately. An appropriate type of degree and transparency shall be ensured, and the information referred to in this article shall specify the human oversight measure referred to in Article 14, including the technical measures put in place to facilitate the interpretation of the output of AI systems by user. So we see that Article 13 really used the word interpretation and interpret. And if we look at Article 14, we see that again the concept of interpretability is mentioned with regard to human oversight measures, prescribing that one of the possible measures to achieve human oversight is to enable the user to correctly interpret the high-risk AI system's output, taking into account in particular the characteristics of the system and the interpretation tools and methods available. So interpretability is a mandatory measure, alternative with regard to other measures, to make sure that a human is always kept in the loop, so that it's possible to oversee the behavior of the AI system. However, although the phrasing of these articles in the new proposal is very clear, and although a lot of computer scientists, when reading these articles, really think that there is a right to interpretability, I would say that this is not sufficient to say that in the AI Act proposal, a right to technical interpretability is enshrined, because the phrasing is not that clear. It's not really possible to say that the AI Act prescribe the use of interpretable models. In fact, this wording can be also interpreted as to a mandatory requirement to provide technical documentation, or also explainable models. So I wouldn't say that we are already there in enshrining our right to technical interpretability. However, I propose that a right to technical interpretability is recognized at a European level as a fundamental right in some situation. So, in situation in which the fundamental rights of citizens are at stake, the right to technical interpretability should be recognized, because only interpretable models can lead to bias detection or bias mitigation, because with a black box model, it's not possible to really mitigate biases from a technical point of view, because the model is not built in a way that you can really influence how the different weights how the different parameters and layers are built. It's also important for the informed consent. So an interpretable model would guarantee a real informed consent to users and to data subjects, because it's the only way in which you know exactly why the model has reached a certain conclusion. it also generates more trust, for example, in operators such as healthcare professionals. And also, it's important for the right to challenge the decision and to also to sue, to have a lawsuit, to have all the important information, to have a lawsuit toward the producer of the model or the provider, the operator that is using the model, the automatic model, such as, for example, the hospital. If you don't know what is happening, you cannot challenge this. So a patient would be unaware that there is a discrimination towards them because it's not possible to understand why the output was produced. So that's why it's extremely important to have an interpretable model. Not in all situations, because there are some fields in which it's not essential. And in some cases, such as image recognition, image analysis, that it's not that fundamental to have interpretability, because a picture is a picture. You can really see it with your own eyes. There's nothing covered or hidden in an image. So I wouldn't advocate for interpretability for image analysis, for example, MRI scans or ultrasounds images. That those models, although they are black box models, are very important, and also they are very precise. So there are also some other considerations that we can make in this topic. For example, using multimodal AI models, so combining different models. So you can still use a black box and you combine it with an interpretable models, or using different information. You can still use black boxes when really needed, and also implement human oversight measures, and that is having a real oversight of the machine, not just a formal human in the loop, but really a substantial reasoning made by a human being that can intervene, that can really oversee the behavior of the system. So I'm not saying that black boxes cannot be used anymore. I'm just saying that in some situation where the fundamental rights are at stake, then interpretable models are really essential. And thank you. If you have any questions, I'm here, and I really thank you for inviting me here.
Thank you so much, Chiara, for your presentation, and congratulations for your work. It was very interesting. Now we leave the floor to Juanita Goicovici. Please, Juanita, introduce yourself and your lines of research before the presentation of your paper. Thank you, Juanita. The floor is yours.
Thank you. My name is Juanita Goicovici, and I'm an assistant lecturer at the Faculty of Law of the Babes-Bolyai University of Cluj-Napoca. So the topic of my presentation today relates to the innovative versus recurrent perspectives on the liability for autonomous and incorporated artificial intelligence, especially for autonomous and incorporated AI engaged in prejudicial episodes, which continuously raised interrogations for legal practitioners in terms of establishing the contours of the manufacturers, importers, and distributors' liability for AI, while contrasting the versions of subjective liability based on fault or detached from the element of fault, especially in the parameter of artificial intelligence incorporating in products, where the taxonomy of defects covered by the material sphere of the liability, especially in terms of manufacturing defects versus design defects and informational deficiencies, are recurrent features when establishing this type of liability. So the idea of detaching the special liability of the producer or importer from the element of fault has persisted despite possible challenges in order for the civil liability or the manufacturer or importer or the AI provider itself in case of non-identification of the responsible persons regimented in the first two categories for artificial intelligence incorporated or embedded in products which have caused bodily or patrimonial damage. For this type of liability to be engaged toward consumer, the discussions are centered on the fact that it would suffice for an illegal act to be established, launching into circulation of an AI product presenting design defects, for instance, in a causal relationship with the damage that was caused to the consumer and exempting the consumer from providing the existence of faulty behavior or serious negligence of the responsible subjects in the context of an action or omissions that affected the security level of consumption of the respective product. So the triptych of categories of defects which are covered by the material scope of application of the special liability of artificial intelligence for manufacturers, importers, or providers can be distinguished on three levels. First, the objective liability, which covers artificial intelligence manufacturing defects as defects due to the human or artificial intelligence errors or faults occurring in the manufacturing chain, such as human error, artificial intelligence error, or algorithms, or equipment failures. Secondly, types of non-contractual liability for artificial intelligence design defects, exaggeratedly risks compared to the benefits in which the respective artificial intelligence incorporating project was designed, the so-called risk-utility balance. And thirdly, in the absence of deficiencies in the first two categories, the extra-contractual liability may be generated by informational deficiencies consisting of incomplete, inadequate, or erroneous information on the artificial intelligence incorporated in products as described in the proposal for a directive. And we argue that the lacunary decisions, biased outputs generated by the artificial intelligence system, as well as a low resiliency against attempts of other autonomous or product embedded artificial intelligence use or performance, may be preferably treated as product dysfunctionalities, thus permitting the consumer to engage the manufacturer's or the importer or retailer's liability for specific damage, while preserving the duality of autonomous material damage versus derivative material damage, as well as a dichotomic approach to the categories of liability for product security deficiencies versus artificial intelligence design flaws. So in terms of recurrent premises and features of liability for defective products, the epitome of the risk-benefits test remains essential in the contemporary physiognomy of specific liability for autonomous or embedded artificial intelligence defective products, which is considerably influenced by this battle of preeminence led between the two possible classical criteria for assessing the product's defectiveness, namely the consumer's legitimate expectations test in relation to the risks benefits test. And far from forming a true hierarchy or preeminence, each of these tests provides for a different role for the national courts. reporting an abstract standard while approaching the experiences of the average consumer, or reversely taking into account typical expectations regarding the safety of an AI product, and on the other side, the engaging in the administration of evidence from which were emerged the ostensibly or unreasonably exorbitant weighting of risks for consumption by reference to the benefits of the consumption or the use of the respective artificial intelligence products. At one of the poles, the test of the reasonable expectations of consumers, according to which defendants are liable if they have manufactured an incorporated, embedded, or autonomous artificial intelligence product that is on the market in a defective and dangerous condition to an extent beyond what would be contemplated as an ordinary degree of acceptable risk by the average consumer who purchased the respective product through the prismatic of ordinary knowledge or common knowledge possessions of the average consumer in terms of the characteristics of the artificial intelligence product, which implies engaging into the objective responsibility or strict liability of the producers for an AI product that presents safety risks beyond the limit of reasonableness or beyond the safety threshold expected by consumers. At the opposite pole, there lies the risk utility test, under which the defendant is liable for the foreseeable risks of causing damage presented by the defective AI product, which could have been reduced, moderated, or avoided by adopting a reasonable alternative design in case of design defect, where the AI product was designed on the basis of some technical parameters according to which the benefits of consumption are exceeded in an exorbitant manner by the security risks brought by the consumption of the respective products. So the latter uses the framework paradigm of a negligence imputable to the manufacturer who accepted the start of the production process on the basis of plans designed in an excessively risky manner by referring to the benefits of the targeted utility, the so-called AI design flaws. So in practice, the non-digital products, especially for embedded AI, the courts oscillated between the two criteria. It was highlighted that the courts either intermittently adopted one of these criteria or consecutively used both tests, forcing consumers to navigate an inhomogeneous legal landscape. So on the other version of the discussion in judicial practice, salient interrogations were raised related to the finding by national courts of potential yet unmanifested defects of the incorporated or autonomous artificial intelligence products placed on the market as a basis for engaging the specific liability of the manufacturer or importer provider in the context where the current provisions of EU regulations are sublime in this respect. So these aspects are curatorial for an unfashionable aporia pertaining to the problematic issues of specific liability for designers or providers of artificial intelligence potential defects whose manifestation has not been triggered. So as mentioned, the notion of serious risk has been recently used to describe a risk for which, based on a risk assessment and considering the typical and foreseeable use of the product and the combination of the probability of the occurrence of a danger of injury for the consumer and the degree of severity of this injury requires a judicial reparatory or redress intervention, including in cases where the effects of the risk are not immediately obvious for the consumer. So the fidelity towards this objective nature of the specific liability for defective products has been kept in the text of the AI liability proposal. In also for manufacturers or AI providers, civil liability for defects that have caused bodily or patrimonial damage to be engaged, it would suffice for an illegal action or omission to have been established. For design defects, for instance, or the launching into circulation of an incorporated or embedded AI product with design defects in a causal relationship, or at least in a sufficiently characterized nexus with the damage that was caused to the consumer, not being necessary that this action or omission were imputed to the manufacturer, or in the other words, the consumer being exempted from providing the proof for existence of guilt or serious negligence of the responsible person in the context of an action or omission that affected the security level of consumption of the respective AA product. Thus, the plaintiff or the injured person is not required to prove that the unlawful action or omission was carried out with the intention to harm, the establishing of significant fault, malice, or inexcusable negligence not being necessary to be proven by the consumer in the perimeter of the specific liability for the AI defect. Therefore, it is worth noticing that the complaining consumer would not have to prove the fact that the author of the design flaws or manufacturing omissions foresaw the consequences of the omissive conduct and followed or at least accepted their reverberations. So the existence of culpable behavior in the form of intent or culpable omission is irrelevant for engaging the extra contractual specific liability for AI manufacturing or design defects, respectively for AI informational deficiencies in business-to-consumer relations. Title 4 of the AI Act concerns certain AI systems to take account of the specific risks for manipulation they pose. So transparency obligations will apply for systems that interact with humans or are used to detect emotions or determine association with social categories based on biometric data, or generate or manipulate content in terms of deep fakes as a type of artificial intelligence used to create convincing images, audio, and video hoaxes or deceptive material. When persons interact with an artificial intelligence system, or their emotions or characteristics are recognized through automated means, users must be informed of that circumstance. If an artificial intelligence system is used to generate or manipulate image, video, or video content or audio content that appreciably resembles authentic content, it generates an obligation to disclose that the content is generated through automated means, subject to exceptions for legitimate purposes in terms of law enforcement or freedom of expression. Chapter 5 of the Artificial Intelligence Act explains in detail the conformity assessment procedures to be followed for each type of high-risk artificial intelligence system. So artificial intelligence systems intended to be used as safety components of products such as machinery or medical devices with embedded artificial intelligence, etc., will be subject to the same ex ante and ex post compliance and informant mechanisms of the products for which they are a component. So the key difference is that the ex ante and ex post mechanisms will ensure compliance not only with the requirements established by sectorial legislation, but also with the requirements established by the AI Act. So as regards the standalone high-risk artificial intelligence systems that are referred to in Annex 3 and the third annex of the Artificial Intelligence Act, a new compliance and enforcement system will be established, which follows the model of the legislation implemented through internal control checks by the providers, except for remote biometric identification systems that would be subject to third-party conformity assessment. So a comprehensive ex-ante conformity assessment through internal checks combined with a strong ex-post enforcement could be an effective and reasonable solution for these systems. There are also differences in approaching the epitome of substantial sphere for liability covering product defectiveness. In the Artificial Intelligence Act, the notion of publicly accessible space, which will be understood as referring to any physical space that is accessible to the public, irrespective of whether the place in question is privately or publicly owned, while in the revised Product Liability Directive and similarly under current Product Liability Directive, the accent is placed on the personal or professional use of the product. In terms of legal uncertainties and regulatory gaps, the Artificial Intelligence Act does not address the problematic of establishing the personal sphere of responsible persons, the liability of whom may be retained in harmful conduct of defective artificial intelligence hypotheses, not answering interrogations such as who should adequately be included or excluded from the notion of AI producer and who would be legally treated as operator, given the fact that AI systems may be trained with third-party providers or by the AI operator, provider, or the AI designer. On the other version of the discussion, under the provisions of the third chapter of the revised Product Liability Directive, the contributory actions of third parties do not reduce the liability of the manufacturer, whereas the contributory actions of the injured person may do so. So it is worth emphasizing that not only strictly manufacturing defects are included in the substantial sphere of the application of this specific type of civil liability, which also includes design defects, the so-called design flaws and design inadequacy, respectively the deficiencies or omissions for delivering correct and complete information to consumers on the risk of AI embedded or the technical characteristics and parameters, limited performance of the autonomous or incorporated AI product, etc. So the absence of adequate information regarding the risks resulting from the typical and foreseeable use of the products represents per se a defect of the product for which the manufacturer or the AI importer can be held liable under these regulations, especially for the physical or patrimonial damage caused to consumers by the defective product. So the conceptual typical pillars encompass three categories of defects attributed to manufacturers, which can be identified as stricto sensu manufacturing defects due to an unwanted syncope in the production chain, or human errors, malfunctions of facilities, or AI embedded in products. And in these assumptions, courts analysis start from comparing the characteristics of the resulting AI products to the admissible safety standards in terms of the perimeter of specific liability for defective products with respect to the proportionality exigencies for ordering disclosure or preservation of evidence on suspected high-risk artificial intelligence systems, assessing the plausibility of the claim for damages remains crucial in the perimeter of courts ordering disclosure of relevant evidence on suspected high-risk AI systems. So the core issue of claim plausibility encapsulates, in my opinion, this necessity for national courts to establish the existence of sufficient grounds for ordering disclosure or preservation of evidence on suspected high-risk artificial intelligence systems causing harm to consumers. So the mentioned mission of the national court enters a retaliatory battle with the exigencies of considering the legitimate interests or the fundamental rights of third parties concerned, particularly the protection of trade secrets or confidential information, notably information related to public or national security in terms of using AI systems. So cyclically recurrent in this perimeter of proportionality assessment, the problematics of respecting third parties' legitimate interests is conjunctly related to the offering of procedural guarantees that the defendant ordered to disclose or to preserve the evidence of an artificial intelligence defectiveness has appropriate procedural methods to contest the procedural legitimacy. To conclude, there are also limits in and errors in identification of an artificial intelligence producer, since the AI product manufacturer is expected in principle to be held responsible for covering the damage caused to the consumer, on the main pillars that the producer has been expected to exercise control over the process of design selection. While engaging in a profit-oriented activity, the manufacturer is expected to assume the risks resulting from the performance of these activities, to the extent that the manufacturer or the AI designer or importer cannot resort to exemption clauses. So as resulting from this desiderata, incorporating in the AI liability directive project, obligations and responsibility related to the use of AI technologies is expected to be placed on the actor most able to control a specific risks. Additionally, salient attention is devoted to the fact that the AI products providers in the EU are subject to this regulatory framework, regardless of whether the operator is established. Thank you so much for listening.
Thank you. Thank you so much, Juanita, for your presentation, and congratulations for your work. It was very clear and interesting. Unfortunately, the last speaker had a setback, so we can start with the discussion and the question for Chiara and Juanita. The first question is for Chiara. Chiara, please tell us when you are ready to move on to the second slide to get a complete idea of the question.
Yes. Okay. I can read the question.
Yeah.
The right to explanation is a hot topic, and the essay is very interesting. The position of interpreters is not peaceful, with some believing that the right to explanation is provided for in the GDPR and others believing it is not. On this point, even the AI Act does not seem to have given clear answers. The risk-based categorization that the AI Act introduces has the merit of differentiating and making the regulation of different realities more or less intense, mirroring the differences between artificial intelligence applications. One wonders, however, whether the use of transparent algorithms remains merely a wish. Critical issues seem to be inherent in the way algorithm works. It seems that the most accurate algorithms are also the most complex ones, where many variables and many levels of abstractions are used in analyzing them. And in particularly sensitive areas, the use of increasingly accurate algorithms would be desirable. For example, in the medical sector, it is necessary for the algorithm used to be as accurate as possible. However, this could result in a lack of understanding of the output of the system. Thank you for the question. I can answer the first one. It touches a lot of important points. The first one is the accuracy of interpretable models. While it is true that in some domains of computer science, black boxes are more accurate, such as image analysis, it is not really true that in all applications black boxes are more accurate than interpretable models. For example, fuzzy logic models are very accurate, and you can look at PyFume, for example, where it is proved that it's has been shown empirically that some interpretable models are as accurate as black boxes, and only few parameters are necessary to make an output, a reliable output. So for this reason, I still believe that interpretable models should be used. As I said in my presentation, not in all domains, because sometimes it's more desirable that black boxes are used. But when it's really necessary to understand what is going on in the decision process, then it's when interpretability is crucial. And even if on the paper the model is very accurate, so the performances are very high, it doesn't mean that in real life it is the same. So let's say, for example, a model has a 98% of accuracy, so it's very, very performative. It's very good from a computer science point of view. But what if the 2% of errors is related only to a specific category of people? What if in the 2% of cases, only let's say foreigners of a certain ethnicity are left out? So is this acceptable in our legal system? I don't think so. So even if the performance is very high, it doesn't mean that it's okay. It doesn't mean that it's good. So there's a lot. I'm sorry that I only have limited time, and also the paper had a limited a number of characters, so I could not really delve into the discussion how I would want. But let's just remain that the conclusion that I still believe that interpretability is very important, and we should pursue that. Okay, so the next question is about readability. Part of the doctrine speaks of sort of readability of the results and not explainability, because this would not be technically possible. This is seen as an acceptable middle way. The creation of algorithms about whose operation programs are able to provide relevant information about how the machine works, system architecture, and how the data is analyzed. So providing only that information necessary to enable data subject to exercise the rights guaranteed by GDPR. I asked the author what she thinks about this solution. The idea of a right to explanation of automated decision as a fundamental right is interesting. However, I wonder whether making it a fundamental right does not risk being, on the one hand, just a statement of principle that is not in fact enforced, given the technical difficulties, or whether it might otherwise lead to paralysis in the use of more complex and more accurate artificial intelligence techniques. Well, I kind of already answered to this. There are some interpretable models that are as accurate as black boxes. We need to fund this kind of research and try to go toward this direction. Of course, if you only finance the black box research, then you will have more accurate black box models. But if we start going in this direction, if we advocate for this, then also the research will progress in this way. So last question, is predetermination of risk level synonymous with staticity? Can the risk-based approach be said to be oriented toward the protection of fundamental rights, even if it's not explicitly mentioned in the text of the proposal on artificial intelligence? Also, this is one of the criticism that has been directed toward the AI Act proposal. Many people said that a fundamental right protection should be stated more clearly in the text of the proposal, and that the risk approach is not the best approach that could be used. Well, personally, I believe that it's very limited. Because they linked the category of risk AI very. So they linked the high risk system to other regulations, such as the medical device in vitro regulation, machinery regulation, and such. So this limits a lot the application of this proposal. I believe it's being reviewed right now, and I hope they will expand this. For example, they only state that conversational agents need to disclose that they are not human. But I don't think that this transparency obligation is enough. For this system, we have seen how GPT is now causing a lot of problems to multiple stakeholders. So I would say to a certain extent, fundamental rights are still protected by the AI Act proposal, but it's not sufficient. So that's my view on the topic. Thank you very much for the questions.
Thank you a lot, Chiara. Now we have a question for Juanita.
Right, so one of the main innovations in the text of AI liability directive is the liability regime that it provides for. So this debate is critical when it comes to the right of the victim to get compensation for a harm caused by an AI-driven system. Indeed, a strict liability regime is more favorable to victims than a fault-based liability regime, since claimants or consumers do not have to prove that the fault has been committed by the service provider or the AI user. So it is important to observe that when a strict liability regime is applied, for that person to be found liable, the victim has only to prove that the risk stemming from the sphere of the liable person materialized. And this topic remains at the very core of the public consultation that the European Commission launched on this topic. And overall, the proposal reflects this type of a balanced approach. The directive implements a fault-based liability regime as detailed in the explanatory memorandum, according to which the directive applies to non-contractual liability claims for damages caused by an artificial intelligence system where such claims are brought under fault-based liability regimes. However, Article 4 introduces a presumption of causality or a reputable presumption of the nexus between the fault and the harm suffered by the claimant consumer. In certain cases, this type of presumption of causality will become applicable, which makes any tort claim much more simple for the victim to engage in. So in this respect of the Article 4, this text lists 3 scenarios which would trigger this presumption of reputable causality. Firstly, when the claimant can prove that a fault has been committed where the artificial intelligence service provider or user does not comply with their duty of care, to which the proposal for AI directive refers to. So the causality link between the fault and the harm suffered is presumed for the final consumer. Secondly, the causality link is presumed where it is assumed to be a reasonably likely, with regard to the specific circumstances of the case, that the fault generated the abnormal output of the artificial intelligence system or did not generate a typical output thereof for the final consumer. So this causality link is eventually presumed, where the victim can prove that the output generated by the AI system or the absence of unexpected output has given rise to the damage. So in terms of this presumption of applying this presumption of causality, I believe it represents a real progress in terms of consumers' right to redress, especially in this context of faulty based liability. And this type of taxonomy is also applicable to artificial intelligence systems which are opaque or lack transparency in terms of autonomous decision making. For instance, claimants may find themselves in a difficult situation when they suffer harm as a result of an artificial intelligence system malfunction, since it is truly difficult to prove that the specific output caused the damage, or conversely, that the failure of the system to produce an output caused the damage.
Thank you, Anita. And this was the last question, and our session is coming to an end. Once again, I would like to thank all the speakers and those who attend the conference. I would like also to remind you that the conference will resume at 2:00. And we are waiting for you with the last session, legal tech session. So thank you to all, and have a good day.
Thank you.
Thank you. Bye.
Thank you very much to everyone. Bye.
Bye-bye.